You're watching The Drum. With me on the panel, Managing Director of Islamic Superannuation Fund, Crescent Wealth, Talal Yassin, Senior Journalist at the Saturday Paper, Rick Morton. In Melbourne, Senior Counsel at the Victorian Bar and Labor Party member, Fiona McLeod. Fiona was also the lead Commonwealth lead on the Commonwealth team into the Royal Commission into Institutional Sexual Abuse, Child Sexual Abuse, and in Tamworth tonight, farmer and Managing Director of rural and regional consultancy firm Sefton's, Robbie Sefton. A study in extremes, the finding of a unanimous jury overturned by a unanimous judgment from the High Court. A man who says justice has been done and the father of one of his accusers left with no faith in the country's criminal justice system. The High Court today published its view that, on the assumption that the jury had assessed the complainant's evidence as thoroughly credible and reliable, the evidence of the opportunity witnesses nonetheless required the jury, acting rationally, to have entertained a reasonable doubt. And citing a previous judgment, the court said there was, quote, a significant possibility that an innocent person has been convicted because the evidence did not establish guilt to the requisite standard of proof. In a statement, Cardinal George Pell said he consistently maintained his innocence. He said he felt no ill will towards his accuser and did not want to add to the hurt and bitterness. Quote, the point was whether I had committed these awful crimes, and I did not, he said. This has been a long time in the making, a reminder of the lengthy court case. In 2015, a former choir boy alleged to Victoria Police that he and another boy was sexually abused by George Pell in the 1990s, shortly after he became Archbishop of Melbourne. The second man had died the year before of a heroin overdose. In 2017, George Pell, then in Rome, was charged with multiple sexual offences and ordered to appear at Melbourne Magistrates Court in July. In May 2018, Cardinal Pell was ordered to stand trial over multiple sexual offence allegations, divided into two trials: the Cathedral trial, involving two choir boys, and a second trial known as the Swimmers trial, which ultimately did not go ahead. George Pell strenuously denied all allegations and said he would plead not guilty. In August 2018, the Cathedral trial began, though a suppression order meant it could not be reported on. The jury failed to reach a verdict, and a retrial in December convicted the Cardinal of one charge of sexual penetration of a child under 16 and 4 charges of committing an act of indecency with or in the presence of a child under the age of 16. In March last year, Cardinal Pell was sentenced to 6 years prison with a non-parole period of 3 years and 8 months. He appealed, but that was dismissed in August by the Victorian Court of Criminal Appeal. Pell then applied to the High Court for special leave to appeal that decision. Last month, the High Court heard that application, and today it quashed his conviction, setting him free after more than 400 days in prison. The Prime Minister, responding to the discussion, noted the reaction from many survivors of child sexual abuse.
I'm staying focused on the coronavirus today, thank you very much. The High Court has made its decision, and I know for many Australians, the memories of things that completely unrelated to that case, which has now been addressed in the High Court, just the mere discussion of these topics brings back great hurt. And when these things are raised, my thoughts are always with them. But the High Court has, the highest court in the land, has made its decision, and that must be respected.
Lawyer Lisa Flynn represents the father of one of the choir boys who died. She said her client is in shock.
He was certainly hoping that it would be over, but he was really hoping and thought that George Pell would remain in prison, given that a jury unanimously found him guilty of the crimes against his son and the other choir boy.
Again, the High Court has today acquitted Cardinal Pell, finding there is reasonable doubt. Chrissy Foster is an advocate for people impacted by child sexual abuse. 2 of her daughters were abused by a Catholic priest in the 1980s. I spoke with her earlier about her reaction to the decision and how the complexity around juries, appeals and reviews will affect victims who might want to make future claims.
After everything, I've had friends ring up in tears, crying. When you're involved you take this all very personally because we've lived it, we've been there, we are there, it never goes away. For me, it's inside me with two of my children. And we just take this on board. It's a personal assault to us as well.
Do you think today's judgment of the High Court will have implications for future complainants?
I could see it putting people off. What is the point? Really, it feels like that. Why would you bother? Why would you put yourself through that?
You might not be happy with the outcome, but we have seen this go all the way to the High Court of Australia. Do you have faith in the legal system after today?
Well, I did have faith in the legal system because George Pell was convicted. And now, I don't know, what faith do you have? It was a guilty verdict, and then that was upheld in the appeals court here. And now it doesn't exist anymore. So what faith can you have in that? It's a shifting sands. How can you stand on that? How can you rely on that?
The original case was heard in Victoria, and the Victorian State Premier Daniel Andrews released a statement today, and he said, "I make no comment about today's High Court decision, but I have a message for every single victim and survivor of child sexual abuse. I see you, I hear you, I believe you." What's your reaction to that?
Yes, well, that brought tears to my eyes. And I think his message just speaks to us of his understanding. But I just wanted to point out it was a beautiful message, and I thank him for it and all he has done.
Rick Morton, can I start with you? You covered the appeal in the High Court. What were your thoughts on today's ruling?
I wasn't surprised by it, I have to say. I mean, I didn't make any public predictions at the time because why would you? The justices of the High Court are inscrutable in so many ways. But, you know, as someone who doesn't have any legal training, I left those 2 days of hearings with the... I couldn't see how the burden of proof could get to the standard required for the prosecution. And that's essentially what the High Court has found. I mean, at the entire time, there was a reversal of the onus of proof, according to the justices. And there were key kind of testimonies that didn't marry up when you looked at them on the whole of the evidence. You know, I think the High Court made the decision, probably the only decision it could have in the circumstances. But I do note that George Pell's right in the sense that this case was not a referendum on the Catholic Church, nor was it a referendum on the handling of child sex abuse carried out by priests who have been convicted of that abuse, and the moral tale, you know, the long tail of the moral kind of judgment that it gets attached to the way this has been handled and mishandled for so long in this country will continue. I mean, this is not the end of that story, and I think this was one particular case decided by the highest court in the country on very specific facts that do not go to any other kind of case that might involve victims of abuse or people who were let down by institutions that should have looked after them and didn't.
Yeah. For more on this, we're joined by former Justice of the Supreme Court of New South Wales, Anthony Wheely, QC. Good evening, how are you?
I'm very well, thanks, Ellen.
Were you surprised by the verdict, Anthony?
No, I wasn't surprised. Of course, there were 7 judges of the High Court, you know, our most preeminent lawyers sitting on this case. So, in one sense, you couldn't foretell precisely what they would do, but I think it's been commonly regarded by quite respectable people in the legal profession for some time that there was every possibility that this case would result in a reasonable doubt being found, and that's exactly what's happened.
So give us some insight into judicial thinking. It seems that even if a jury assesses a complainant's evidence to be, in the words of the justices, thoroughly credible and reliable, the High Court can overturn it. Why is that?
Well, I think you have to go back to basics here, Ellen. The system we have is that we have trial by jury. And trial by jury means that the community have a very important input into determining guilt or innocence. But like every other decision that's made by judicial bodies, we have a hierarchy of appeals from those decisions. And jury decisions are susceptible to appeal, just as the way as a magistrate's decision is susceptible. There are some important differences, of course, but there's no doubt that a jury decision can be scrutinised and overturned.
Okay.
And I would say people may not know this, but the fact is that day in and day out in our appellate courts, submissions are made that jury decisions that have been made were in fact unreasonable, and the result should be an acquittal.
Okay, so
now, it's also true that that doesn't frequently result in an acquittal, but nevertheless the practice of appellate courts scrutinising jury decisions is very common and has been common in my experience for 20 years.
So explain this to me. There's a lot of talk in this judgment about the opportunity witnesses, right? And these are the people who gave evidence about the usual practices and routines at the cathedral, the age-old church routines, some of them. But hypothetically, it is not usual practice for anyone to sexually abuse a child. So what is the value, Anthony, of an opportunity witness who tells us what would usually happen?
Well, let me just give one example first. I mean, you might have a case where you've got a very compelling witness who says he or she was abused by a cleric, and nobody doubts that witness. It looks extremely likely. And then you look at other evidence and you find that the cleric in question was not even in the country at the time and had not been for many months. So that's a different sort of evidence, but that's exactly the same way that opportunity evidence is looked at. So here you had what's called opportunity evidence and looking at usual practices. Now, there's a lot of legal authority to say that where there is a practice that's commonly carried out, that's very good evidence that it was carried out on a particular occasion. And that's particularly the case when you're dealing with the Catholic Church or institutions of this kind which are steeped in ceremony and tradition. And I might say that in the case of Cardinal Pell, you couldn't get a better example of someone who's steeped in ceremony and tradition. He's hardly the sort of person, from what we know of him, who would cast aside his normal ceremonial way of behaviour.
Okay.
So if it's his practice to meet and greet the congregation fully robed, and if it's the practice that he remains in those robes till he's disrobed by a Monsignor of the church in the sacristy, then that's pretty powerful evidence to suggest that that's what would have happened on the occasions where he's alleged to have abused these children.
Fiona, can I have your reflections on that?
Well, first I want to echo the comments.
I just lost my connection.
Okay, all right.
I said
Fiona, come to you.
Yeah, sure. First of all, I want to acknowledge that many people will be gutted by this decision and echo the comments of the Premier, which were very appropriate in the circumstances. In this case, the court found that there was a significant possibility that an innocent person has been convicted because the evidence did not establish guilt to the relevant standard of proof. So ultimately, as the High Court tells us in this case, there should have and there was a reasonable doubt concerning his guilt in the circumstances. So really, no matter how believable a witness is and how credible and cogent their evidence is, a prosecutor has to meet that very high threshold test of beyond reasonable doubt. And if the evidence suggests a reasonable doubt remains, the defendant is entitled to the benefit of that doubt. And this really underscores the difficulty of proving cases in a historical context, because strict burdens of proof mean that in many cases of offending, offenders may not be brought to justice because of gaps in the account of the complainants and difficulty in finding that corroborating evidence. And it also points really to the absolute necessity of the measures that have been introduced by the Royal Commission. Well, I mean, we've had more than 5 years of harrowing cases being brought to our attention, and we know that sexual abuse remains a serious issue in our community. it is the case that victims of that abuse should not be silenced anymore, and that our children absolutely must be protected.
Okay, but
there's a range of measures now to address that from a civil perspective in terms of redress schemes and so on, but the criminal justice system still requires this standard of proof.
Anthony Willey, if I can come back to you, what do you say to people tonight who are so disappointed by this and who look to the statements to the statements of the Prime Minister back on the 22nd of October 2018, who said we must listen to children and believe what they tell us. And that idea did seep into everyone's imagination after the Royal Commission, that notion, you will be believed.
Well, Ellen, can I put it this way? This trial, and these appeals have been going on for 5 years. And I think that they have assumed a very significant note in people's minds. I think that George Pell has really become a symbol in some people's minds of all of the abuse heaped upon people by the church. And because of that, I can understand fully why victims or supporters of victims and why other elements of the community feel so badly about this. But I do believe that they are wrong, with all due respect. They're entitled to be disappointed because of the elevation of Pell to be a symbol. But in fact, he's charged only with 5 offences committed over 2 days. And the resolution of those matters was, in one respect, straightforward. It was by the application of simple, well-established principles. There's nothing new in the High Court's decision. There's nothing startling about it. And I would say to these people that they need not fear that victims should in any way be inhibited from reporting abuse, and they should not fear that convictions won't continue to be recorded against people who commit these abuses. If you go into our district and county courts each year, you'll see that there are priests, clerics, religious people, other people, members of the community convicted of sexual abuse regularly. Yeah. And nothing in this decision and nothing in the George Pell case will change that.
Rick, if I can turn to you, in George Pell's statement, he used the term manufacturing obscurity. He said that there were efforts to throw light on manufactured obscurity and to reveal the truth. What does he mean by that? Who manufactured obscurity in this case?
Look, I mean, that's an awful phrasing, awful set of words. I read it, and being genuinely honest here, I read it as referring to the prosecution. Because having sat through those hearings, there was a tension between the two sides, as there is in an adversarial system. But really, the prosecution were trying to say, well, we've got very compelling and very believable testimony from the complainant. Don't worry too much about all of the other opportunity evidence because we can make that fit. And I got the sense that George Pell was referring to the push from a legal point of view, not from the victims, or from the accusers, but from a legal point of view about trying to match up different narratives and sets of facts. And
how would you balance this in your reporting? That disappointment we heard from Chrissy Foster and the clear unanimous verdict of the High Court of Australia?
I think it's one of those rare examples where all things can be true, right? We do have this justice system. I mean, nothing aberrant has happened in this particular case in the High Court. It was, this is almost the natural outcome of what they were looking at in this particular case. If you've sat through the hearings, you would know that. But there is grief, and of course people are hurting, and people are hurting who don't even have any particular attachment to this case, but who have been abused, who have been degraded, or made to feel less than what they are, right? And that grief, it's its own thing. You don't change the size of that grief with an outcome, a judicial outcome like this. It does, the only question I think that rises above both of those things, which are both true, is going forward, how do you get the balance right, particularly for child sex offences and historical ones where you're going back 20 years. And in many cases, it really does come down to one set of words versus another set of words in people who were alone in a room with no witnesses. and they are the hardest things to prosecute. So yeah, there's grief and outrage, and people are lashing out. I mean, I don't think it's helpful to cast aspersions on the court, like some people were today, saying that the High Court now approves of pedophilia, because that is so far from the truth and so far from what happened in this case. And this case is not about the handling of child sex abuse across the Catholic Church. And, if you believe in a God, and certainly George Pell seems to believe in a God, that God will be the ultimate judge of all of these matters, including how the Catholic Church handled kind of systematic, high-profile and frequent abuse over decades that they knew about, the Church knew about, and moved people to protect the priests and not the children. And there will be a judge for that stuff.
Thanks so much to our guest tonight, Anthony Wheely. Anthony is a former Justice of the Supreme Court of New South Wales. Thank you so much.
Thank you. Thank you very much.
No worries.